It's March 20th, 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. Today we're headed into Judge Middleton's courtroom for a landlord-tenant docket that proves truth is often stranger than fiction. We've got a logistical nightmare involving a handshake farm deal and 17 tractors with nowhere to go. We've got a divorce without a marriage featuring a $700 BMW key and a messy illegal lockout. And finally, stick around for a high-stakes legal showdown as two veteran attorneys clash over federal housing subsidies. Judge Middleton is herding cats today, ladies and gentlemen, so buckle up, get a drink, and as always, it all starts right now.
Very hectic morning.
Looks a little busy out there.
Going on here this morning, both here and next door. All right, good morning. We're ready to begin our landlord-tenant docket in about 2 minutes. We've got a lot going on. We've had a lot going on already this morning. Had an 8 o'clock meeting with the other judges. Judge Patterson's busy next door. I got people in the waiting room. Good to go. All right, today's little shared moment of humanity. Everybody's high on consolation. Everybody's trying to tell me what is right for me. Yeah, my daddy's trying to bore me with a sermon, but it's plain that they can't comfort me. All right, I got to get right to it this morning. All right, we kind of bumped our way through the first case. We've gone through the rights with Mr. Peck, and we'll address his case, and then we'll take up our next one. Mr. Lance Thornton is here with me live at the courthouse on this matter on behalf of Borgert Family Farms against Ryan Peck and Zane Peck. Zane Peck is not here, but Ryan is. So both are there? Okay, Zane and Ryan, both defendants are present. This is filed as a termination of tenancy action. Mr. Thornton caused to be served on you a notice to quit on January the 2nd, asking you to move by February the 2nd. You didn't move, so he filed this action. There is no lease that I could see here. And at this point, Borgert Family Farms LLC wants this property back. Is that correct, Mr. Thornton?
That is correct, Your Honor.
Mr. Peck, what's your position?
I had a conversation with Keith Borgert last night. I farm for a living. I have a lot of equipment there. I had a good deal with Keith, and then the mother Doris passed away and everything changed, which I understand. When I talked to Keith last night, he told me to see that he thinks June 1st, I'll have everything out of there. And that's what Keith also thinks is fair. And he's a Borgert. He's the guy who originally got the property through.
Well, he's not the owner of the property. The property belongs to Borgert Family Farms LLC. This happens a lot when the patriarch or matriarch passes, that's left to the kids. And then there are issues regarding that. They want you to move, not June, but now. What kind of stuff have you got there? Like major farming equipment?
Yes, I run my farming establishment out of there. So everything is there, and I have a place coming up April 21st. It's Oswald Farm. The father passed away, but they had to wait the 4 months. You know, he inherited it. So it's going to be April 21st before we can do anything there. So, and I talked with Keith, and he says he's going to talk to Cindy, the other Borgert. And he said he couldn't see why June 1st was a problem.
Well, they can certainly agree to that. There may not be agreement among the siblings as to what to do with this. The good news is we have to adjourn this matter at least 7 days. But this is more than just moving you and your bed and television out of there. You got lots of heavy duty farming equipment. So they're outbuildings, barns, that sort of thing.
Correct, Your Honor. And they're full. I mean, I've got 17 tractors there, 5 semis, my combine, my planters. I mean, everything for a farm is there. And I don't quite know where to move it to until April.
And you never had a lease?
No, me and Keith are good old country boys, and a handshake is what I go by, but I will never do that again. So,
The unfortunate part, Your Honor, is Keith Borgett never had authority to rent the premises.
And he told me he did, and you know, I've been there 2 years and nobody's ever said a word until Doris passed away.
Did you pay rent
Yes, $3,300 a month.
to Keith?
Yes.
Well, that's a pretty good deal for him. All right, well, this is complicated. As Avril Levine says, we're going to continue this to next Friday. Now, how is Borgert Family Farms LLC and Keith Borgert getting along?
Okay. The actual operating manager is Cindy Borgett of the LLC.
Okay. Well, perhaps they can work out some sort of agreement that he agrees to get his stuff out of there by a certain date, more than just 10 days from now. But today is the 20th of March. I'm going to continue this to next Friday, the 27th of March. That will be in the afternoon because we have pretrials that morning. How about 1:45 next Friday, March 27th?
That works for me, Your Honor.
That works. I'll be back from Illinois Monday.
Now, in the ensuing week, it'd be very helpful if you and Mr. Thorne and all the Borgerts got on the same page. There could be some sort of agreement where they would issue a conditional order of dismissal. I'm just pulling this out of the air here, but let's just say you agree to move by June 1st. And if you move by June 1st, they could dismiss the case. The worst case scenario is you'd have 10 days from next Friday, March 27th, to move out, which would mean 17 tractors, 5 semis, all your equipment would have to be removed from there by April 6th.
Right.
Now, that's not a good solution because if you don't move it, the sheriff's not going to come out there and remove all that property. This is something that needs to be done by you. But as you indicated, you have no lease, you have a handshake agreement, and he's not the owner of the property. And $3,300 a month times 24 months is a lot of money. And I'm not sure what all that's about, but how many acres do you farm?
Close to 3,000.
Where? All over there in Colon Township?
All the way east of Colon, Farron Road. East is our farthest, clear north of Fulton, Michigan, to Vicksburg, to Centerville, kind of all around.
All right. Well, you don't just pick that up like a suitcase.
No. I got to have a farm to go to, you know, and I'm trying to find one, and they're kind of hard to get nowadays. And
yeah, that's certainly true. All right. Well, Mr. Thornton does agricultural stuff, and he knows the territory, and perhaps some agreement can be worked out. But at this point, in order to start the process, they've served this notice to quit and had this hearing. So we'll revisit this next Friday, I said 145, and I'm not sure that's what I meant.
And when I get back, I can sit down with Cindy and Keith, and I think Cindy and Keith are no problem. It's Sue Roach that I'm being told is the biggest problem with all this.
Is Sue Roach a Borgert, or she's just a real estate agent?
She's a Borgert by, yeah, she was
Oh, I
born
don't
a
know.
Borgert.
One thing we learn around here is everybody's related to everybody else. So at any rate, you guys have got some work to do between now and next Friday afternoon, and we'll see what our posture is at that time.
Did we stay with 145?
Yes, 145.
And I'll
All
be
right,
there in
thank
person this time.
We had a special live appearance from Mr. Thornton because he had to be over here in Centerville anyway. So you guys are welcome to come live, or you can zoom in like this again next Friday afternoon.
I'll be there live because I'll be back.
All right, thank you.
All right. Thank you, Your Honor.
Thanks.
All right. Oh, that is complicated, but we'll see how we do. All right, we've got thank you, Mr. Thornton. We've got John Beachy and Megan Sudbury. We've got Mark Thrasher, who's a plaintiff. We've got Hot Pepper HPP. I don't know who this is. Who's Hot Pepper HPP? Good morning. What's your name? You unmute your microphone. I'm going to retire and teach people how to unmute their microphone as a career. All right, Thrasher is next, and then Beachy, if I can figure out who this dude is. Hot Pepper.
I don't know who that is.
Well, I don't expect it. Maybe you would. Oh, good. What's your names, please?
Lionel Ballard.
What's your name?
Lionel Ballard.
Oh, Ballard and Brown. All right, let me give you a name rather than Hot Pepper. You'd be amazed at what people have logged in here as.
Yeah.
All right, we can go on to our next couple of cases. Ms. Sudbury, Ms. Ballard, and Mr. Brown. And I guess that's it. Mr. Neff isn't here in Mr. Thrasher's case. You are defendants in a landlord-tenant case. In Ballard and Brown, it's a termination of tenancy. In Thrasher, it's a termination of tenancy. And in Beachy, it's a termination of tenancy. In each case, your landlord wants you to move. You have the right to hire an attorney in that situation. If you cannot afford an attorney, you could see if legal aid would represent you in this case, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County, right here where I'm located. The state Supreme Court says I'm supposed to tell you that, but it's never been an issue, not even one time, but it might be one day. Anyway, you have a right to have the case heard here in Centerville. You have the right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of this date, file a written jury demand with the court, and be willing to pay the $50 jury demand fee unless the judge waives that fee for your inability to pay it. You may be able to reach an agreement by going through mediation. That's never happened either, but if both parties are interested, the court could help set that up with our agency, Citizens Mediation Authority, Inc. Or you may be able to reach an agreement with the landlord whereby the case would be dismissed with what's called a conditional order of dismissal. If both parties are interested, counsel could help prepare that. So the first case that's actually set at 9:20, we're about 13 minutes behind, is Thrasher v. Neff. Mr. Mark Thrasher is here. Mr. Thrasher, you and I go way back.
No, you're talking about my brother.
Oh, your brother?
Yeah.
Your brother's also named Mark Thrasher?
Oh, no. Alan.
Well, I know Alan too, but you and I have dealt with each other, I think way back in the 80s, maybe.
Okay.
But yeah, I know Alan as well. At any rate, you wish to evict Colleen Neff. She lives in your same house. And this says there was a bad breakup and there was no lease. She was personally served. She is not here. Is she still there?
She is still there. She just texted me a couple minutes ago that said that she cannot connect on. It says the phone just keeps hanging up on her. But she is watching.
Well, she may have been the phone number that kept coming in and I couldn't get the person to tell me who they were.
I think it was.
All right. Well, she isn't here. She doesn't have a lease. She was personally served and she has 10 days to move out. Has she begun anything to move out?
She started packing some stuff on out. She's getting a storage unit this weekend to move her stuff on out.
Well, calling and hanging up 3 times is not appearing in court. If she is watching, Miss Neff, he is the owner of the house. You don't have a lease. He wants you to move. He served a notice to quit on you on December 1st. It's now March 20th. He wants you to move and you have 10 days to vacate. 10 days from today is March 30th. I'm not ordering any money judgment. You have 10 days to appeal this or to file a motion to set aside the default. But in order to set aside the default, you have to show a meritorious defense and a good reason for not appearing. Let's see who this is.
Says you tried 6 times that call.
Well, someone kept logging in with an 800-8402 and I could never get them to identify themselves and then they'd hang up. All right, here is someone who's logged in as Samsung S9. This is part of the reason why we're so far behind. We've wasted a lot of time trying to identify phantom people like Hot Pepper. Samsung S9, could you identify yourself? Well, I don't know who that person is. I have
that there was her. She's using my tablet. I have a Samsung 9 Android tablet, so I know that was her.
So, Miss Neff, can you hear me? She needs to learn how to unmute it, and then maybe we could. Miss Neff, can you hear me? Miss Neff? You have 10 days to vacate or you are subject to being evicted. I can't tell whether that's you. I'm treating this as a default. This isn't appearing, calling and hanging up or logging in with, I can't hear you or see you doesn't qualify as appearing. So you need to unmute your microphone so I can speak to you. Mr. Thrasher, stick with me for a minute.
I ain't going nowhere.
All right, Miss Sudbury, would you come up and have a seat right over here? All right, the next matter is file number 26311LT. All right, someone's there? Samsung? Who's speaking? They're very disruptive. Who is speaking? Someone's logged in as Samsung. What's your name?
Carolyn McNary.
Oh, Carolyn, you should be better than this at that.
This is only my second time, Judge. I'm sorry.
All right. Well, you're a boulder in the stream, but we'll be with you in a minute on those ambassadors cases.
Yes, sir.
All right. Thank you. All right. So we'll change her name in a minute. Anyway, this is John Beachy versus Megan Sudbury. I went through the advice of rights for Miss Sudbury. I learned about this case a couple different ways. Mr. Beachy is here in the conference room with his children who also live at that South Thompson Lane address. Megan Sudbury is here with me in the courtroom. There is a criminal case going on in this matter, and we had a pretrial on that yesterday, and I spoke to the fact that there would be a landlord-tenant hearing this morning. Everybody's here in a timely manner. There's also a personal protection order, which is Judge Pattison's bailiwick. I'm not sure how he got it. Anyway, Mr. Beachy and Miss Sudbury were living together in Mr. Beachy's home on South Thompson Lane Road. Domestic assault charge was lodged against Mr. Beachy, and he was compelled to move out of his house. Miss Sudbury was in the South Thompson Lane home with Mr. Beachy's children. At some point, she moved out of South Thompson Lane and moved into a property on Resort Road just across the lake. So Miss Sudbury, are you now living at the Resort Road address?
No, Your Honor, none of that information is factual.
All right, where are you living?
I'm not going to say on the record, but I do have a place. I have a lease. I can provide
All
that
right,
to you.
so you're not living at South Thompson Lane?
No, but that's because they forced me out, and his children were not staying there. He lied about that. His children were not staying there. They were staying with him. I believe they were at his mom's
So
house.
because of this, he and his children all had to move out of his house?
No, then he started sending his children back every day.
Well, it's their house.
Well,
So
it is their
at
house.
what point did you move out?
I didn't technically move out. I left because I am terrified of him and his children. I had documented things.
All right, well, so you're gonna need to get out of here. We just need to
I
figure out the
understand that.
details. So now we were in dispute yesterday as to what is there. Is all your personal property still there?
Yes, but he said yesterday that it's not there. He also said yesterday that he had none of my property on his property, which is false. And I did provide the police report today because he had my gun and he did return it. Well, he surrendered it to Officer Morrill, who brought it to me last night.
All right, yeah, that was a bit cryptic yesterday, Mr. Beachy. You said her stuff is not there. Where is her stuff?
It's in the storage unit, Your Honor. It's not.
Your Honor, I have reason to believe that
Just
that's
a minute.
not all the way true.
Just a
because
minute, just a
okay.
minute. Don't tell me exactly, but what town is the storage unit in?
In St. Joe County.
Who put it there?
the other people that were at the house.
Well, who are those?
My son,
All right.
I didn't return to my house till I believe it was January 30th, a week after she was out.
You can't do that. Violates the landlord-tenant anti-lockout statute. Whether you liked it or not, she was a tenant at your residence and had lawful status to be there. Because of the domestic violence charge, you were in the odd situation where you got removed from your own house. It's a nice house. And apparently either your kids also got removed or agreed to vacate. But you can't take her stuff and just put it in a storage unit. The law gives her certain rights as a tenant. And you were cryptic about it. Now we've got this criminal case and this PPO. But the bottom line is she can't live there anymore. This relationship is ended. She doesn't have a lease. You live there with your kids. The prosecutor asked me to forestall the termination of tenancy case. And I really am not willing to do that. But we need to figure out how to get her and her stuff back to her. So when we talk about your stuff, are we talking about clothing and personal effects, or are we talking about
All
furniture?
personal items, all clothing of mine and my daughter's. I'm gonna say I probably had $5,000 to $7,000 just in shoes.
I bet I have $200 in shoes.
May I say something, Your Honor?
Yes.
Miss Sudbury was made aware that she could have all of her belongings. All I wanted was my items that she took from my house, like my wallet, my car key, my BMW car key that cost me around $780 to replace it because she wouldn't return it. Plus other items.
That came up yesterday. He contends that you took his wallet with his identification, his charge cards, and some of his personal property like car keys. There is a statute that allows the landlord-tenant judge to deal with personal property. Judge Stutzman had a different view of it in a case, but so, and you denied that. So do you have any idea what happened to his wallet?
No.
Nobody's under oath here, so I don't know what the truth is.
She was left in my home when I was arrested, and my kids would never take my wallet. So she was the only other party in my house when my wallet ended up.
All right, so after you went to jail, your wallet disappeared?
Yeah, along with
From
my
your house?
keys. Correct, along with my keys, a pocket knife I had, which mysteriously she ended up producing and giving to my brother and sister-in-law. But they were all together with my wallet and my car key. And my car key and my wallet were the only things that weren't returned, but the other things were, because they were always.
All right, well, I'm not sure what to do with that, but all right, Miss Sudbury, what do you want? What would you like? What would be the best outcome for you?
I would like my personal belongings back. I would like my daughter's things back, and I would like to get out of his home. I would like to do so when they are not present. Because I am terrified of them. I have many, many recordings of his children beating him up. So I am terrified of his children. And Daniel did tell me he is going to, and this is why I left, because I'm afraid of them. Daniel said him and his dad are going to take things away from me and punish me every day until I leave. When we were in Judge Pattison's room for the PPO matter, his attorney, Cyber, had specifically asked if they could lock me out, and Pattison said no. He said, you cannot do that. So that very same evening, that's exactly what he did.
Well, there's an anti-lockout statute and you have some remedies under it, but at this point, you just want to go into their house while they're not there.
I don't have a problem with with peacekeepers, and that's what the officers told me to do. And they told me to break in because that's my residence and it's not malicious destruction of property. I didn't want to harm anything or anyone. I don't want anything to do with their things. I just want mine back. I am afraid of them. I don't want them present. I mean, John's not supposed to be around me anyway, but I definitely don't want his children there.
Well, it's their house. His children don't have a no contact order against you. He does. And that's their house. It's been their house for 15 years. You moved in less than a year ago and everything went sideways and everybody's life is in turmoil. But
Can I say something else, Your Honor?
yes, well, in for a penny, in for a pound. Yes.
I'll gladly pay that pound. This isn't the first time that Megan's done this to an individual. She did this
All
exactly.
right, we don't need to go down that path.
I'm just saying that it's not her first go around doing this to somebody.
All right, well, I'm only gonna deal with this. Now, you've got her stuff secreted somewhere and you won't even tell me where it is other than it's in St. Joseph County.
It's in 3 rivers, Your Honor. Also, I wanted is my things back and she's been made aware of that. I just want my things and she can have everything of hers. I don't
All
want
right, I don't have the authority to give your things back. Not in a context of a landlord-tenant case. I have authority to give her stuff back. Your theory, and it is plausible, is that she took your wallet and your car keys and your knife. And she gave your knife back to your brother, but you don't have your wallet, which has your identification, your credit cards. You had to pay $750 to get a new set of keys for your car. Obviously, the most important thing you want back is your wallet. I don't know whether she has it or not. She says under oath that she doesn't, not under oath, that she doesn't have it.
She took it. Your Honor.
I'm just trying to get her stuff back to her. Now, she contends that she still has items in your house. And she wants to go in your house without anybody being there and maybe a police officer, but they don't like to do this. Like, we have better things to do than stand around for 3 hours while somebody moves out of someone else's house. And we don't know what property is hers and what property is his. So if the sheriff will do it, great. The way it really works is when you move out, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. Samsung, we still haven't figured out who you are. Who are you? I'm going to put you in the waiting room because you are very distractive. What's your name? Oh, that's Carolyn. Miss McNary, I'm going to put you in the waiting room because you're making a lot of background noise.
Done anything.
Hey, Judge,
Yes?
she's talking to me and said that she's unable to connect.
Who is?
Colleen Neff.
Well, she isn't here.
Yeah, it keeps hanging up on her.
You're free to go. She
Yeah, I
hasn't managed to log herself in. She has 10 days to vacate. Calling you on the telephone or hanging up on me 3 times or attempting to log in. Now, someone is here as iPhone. Who is that?
That could be her.
Are you
No.
Carolyn Neff?
iPhone is Carrie Bartholomew.
All right. That's the other thing I'm going to teach people to do is how to give their name on there.
So I'm free to go.
Yes, you can tell her she has 10 days to move out or she's subject to being evicted.
Okay.
All right.
All right. Thank you.
All right. Back to Beachy and Sudbury. The law says we have to adjourn this matter at least 7 days. Mr. Beachy, what you need to do is allow Miss Sudbury to get all of her stuff out of this storage unit that you put it in. That violates the Landlord-Tenant Relationship Act, and violates the lockout law. She can actually sue you for money damages. But we aren't there yet. I'm just trying to get possession back. You need to make this storage unit available to her to get her stuff out of it.
Your Honor.
Yes.
He also previously hauled a whole bunch of my items off of his property when I was still there, in an enclosed trailer. That has been gone for quite some time, and there are $2,000 worth of bikes in there. So I'm assuming, maybe I'm incorrect for assuming, I'm assuming those things have not been put in the storage unit.
You also have a trailer full of her property?
No, Your Honor, everything of hers is in that storage unit.
Including the stuff that was in the trailer?
Yes, Your Honor. That way she had no reason to come back to my house. Because she was packaging up some of my items in hers when I was not at my residence.
Well, this goes under the category of it's your own fault, everybody involved. She moved in, there's no lease, there's no marriage, your kids are there, the relationship goes south. You can't just pick all her stuff up and throw it out in the street, which is essentially what you did by putting it into storage. I want to get her out of there so she can get her new tenancy established. You and your kids can get your house back. So the first thing we're going to do is you need to make the keys to the storage unit available to her. Are you at the Resort Road address?
No, I was not living there. I did stay there for 2 weekends and a couple nights in between, but I never lived there.
All right, what town are you living in?
Three Rivers.
Where, I hope it wasn't at Menards when all the roof blew off.
No, but I do have concerns about the storage unit being one of those that was demolished.
All right, where is her stuff?
It's on M60. I don't recall what the name of it is.
All right, we need to get the keys to her so she can get her property out of there.
We'll do, Your Honor.
How do we accomplish that?
I'm flexible. If he can get them to somebody and give the location and the unit number and I have access to get in, I'm sure it's a gated community.
Yeah, I'm sure it must be. There's a,
I mean, he can give them to anybody and I'll get them, not his children. Though.
Is there an intermediary person?
I mean, can he bring them to Kendra?
Yes, he could bring them here to the courthouse.
My son Daniel can give them to her.
No, I would prefer not to have
All
contact.
right. Why don't you provide the keys to the victim advocate at the prosecutor's office? And then she can coordinate.
One more thing, Your Honor. She was in possession of my key when the police were first called on January 8th. She was in sole possession of that $780 key.
All right, well, we'll see where that goes. It's difficult to deal with that as part of a landlord-tenant case. This is a divorce without a marriage. She wants all of her stuff back. She wants her property back. You claim she's got some of your stuff.
She does, Your Honor.
It's all a bit complicated. So you're going to have your son, or you're right here, do you have the keys with you now?
I don't, Your Honor.
Well, it would sure be handy if you did. You could simply hand them over right here. But we'll have you provide, is that agreeable with you? Ms. Ackerman?
Yes, it is.
All right, the prosecutors, victim advocates are involved in the case from the other aspect, and that would be a good intermediary for the exchange of the keys. Then you need to get in there, and I don't expect you to move everything out of the storage unit, but see what's in there.
Yeah.
Because he claims there's nothing in the house.
I guarantee there is. I'm pretty sure he didn't grab my life jackets. He's got a whole bag of cannabis in his garage. I'm sure that he did not. I have pants in his laundry room, stain remover in his laundry room. I know that those are minor petty things.
Yes, they are.
My children.
Cannabis, I was unaware of any cannabis in my garage.
He's lying. He's the one that showed me the bag. He actually pulled the bag out of the dumpster because I put the bag in the dumpster. He pulled it out.
You know what? This is terrible.
It is terrible.
Stop. I don't want to hear this. I don't do divorce work. You need to get out of there. I don't want to fight about the Tupperware and life jackets. You're going to turn the keys over to the prosecutor's victim advocate.
Yes, Your Honor.
She's going to get the keys and go in there and see what you've done with her stuff, which you lawfully can't do. You can't just take her stuff and put it in a storage unit, but that's what you've done. So I'm trying to unscramble it. So we're going to start by you getting the keys to the storage unit and see what's in it. This is not a small claims case or a general civil claim and delivery case. Let's assume she took your wallet and keys for sake of argument. I don't have the authority in a termination of tenancy case to order her to give your wallet back. I'd have to have a trial on whether or not she took your wallet. There's enough animosity here to last for a decade or two. I just want to get her stuff back and get everybody back to their own life. So you're going to turn the keys over no later than Monday to the prosecutor's victim advocate. They will then contact you and let you know that they have the keys. And then you're going to go get in there, and then we'll see what's what. So let's see what our next date is. I'm going to go 10 days rather than 7. I'm going to continue this to Monday, March 30th at 2:30. All right, let's recap. This is filed as a termination of tenancy action. Mr. Beachy wants Ms. Sudbury to vacate. She's already vacated. He's violated the anti-lockout law by removing all of her property. First thing she's going to do is she's going to get the key to the storage unit and retrieve her property. And then there'll be an issue about what is still missing. Theoretically, Ms. Sudbury, if he gets what he asked for, you would have 10 days from the 30th of March to have no possessory or tenancy issue in his house. That would be April 10th. So if you contend when I see you on March 30th that your property is still in his house, I'll have to make arrangements for the sheriff and probably Mr. Beachy's daughter to be present when you look for the house. Fight about life jackets and cannabis in a sack in the garage and stain remover. We just need to get you out of there. Then, if you believe he owes you money because he damaged your property, didn't return everything, you can sue him in small claims court for up to $7,000. Same thing for you, Mr. Beachy. If you believe she stole your wallet and your keys and it cost you expenses, you can sue her in a civil case for up to $25,000 or up to $7,000 in small claims court. This is a landlord-tenant termination of tenancy case. What it's about is removing the tenant from the property. Now, there's something called the anti-lockout law, which gives a tenant certain rights. The landlord violates that statute. And we're not going to get into that here today because there's no damage hearing. I just want to get you out and get you all of your property. And then if there's money issues, you guys can fight about that in a later case or simply get on with your lives. Now, we still have the domestic violence case, which is pending in criminal court. And that, I think, has a trial date in June. So that's much farther away than I would like, but that's what we've got.
I think it's April 30th.
April 30th?
I could be wrong. I put that in my phone
All right,
yesterday.
that may be the date I used. April 30th sounds right. That's a,
Thursday at 2.
no, that's a final pretrial. That's not a jury date.
Oh, sorry.
All right, so you will bring the keys to the prosecutor's office. They'll call you when they have the keys. So Ms. Ackerman, would you take Ms. Sudbury back to your office? Mr. Beachy, you and your kids can vacate and get back about your day. And we'll address this on Monday, March 30th at 2:30.
Thank you, Your Honor.
All right, thank you. You stay where you are for right now. Why don't you go ahead?
Thank you. Am I dismissed?
All right, you're good to go.
Thank you.
You want me to stay where I'm at, Your Honor?
As soon as Miss Ackerman gets her back in there, I'll up to 20. All right. I wish you had those keys with you today. That would have made it easier.
Actually, Your Honor, my son does have them with him.
Oh, he does?
Yeah, so he's gonna go into his car and get the key and give it to the prosecutor.
Very good. Very good. All right. Why don't you go do that now? And then your son, why don't you have your daughter do it?
Okay,
And turn the keys in at the prosecutor's office.
great. Thank you, Your
All
Honor.
right, I'll see you in 10 days. All right, again, we got some clinkers here. And that matter was set for 9:50, so we're about 35 minutes behind. But our last Ambassador for Christ case is Ambassador for Christ Church versus Carrie Bartholomew. Carrie Bartholomew is here with us. Miss Bartholomew, you are a tenant in a landlord-tenant proceeding. Your landlord has asked me to terminate your tenancy and have you vacate this room you have at this property on South Main Street. As such, you have certain rights. You have the right to hire a lawyer. If you can't afford an attorney, the county could appoint one for you. That's a criminal case. If you cannot afford an attorney, you can see if legal aid would represent you or seek other legal representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first court appearance or file the written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. I'm doing a little house cleaning here. If you can reach an agreement with the landlord for some sort of agreed upon move out date, it could file something called a conditional order of dismissal. And Mr. Duck could prepare that. Or if both parties are interested, I could refer the matter to mediation for an attempted mediate settlement. That's never happened, but it might one day. Miss Bartholomew, are you still there?
Yes, I'm still here.
Have you made any plan to try to move or?
I have actually started moving. I'm almost completely moved presently.
Well, I'm going to adjourn this matter, continue it to March 30th. What time did I set Mr. Duckett's other case for?
2:30, Your Honor.
We'll set it for 2:35.
And I have contacted legal aid. I've been assigned a lawyer on this case.
All right. If you move, you turn in your keys and give your forwarding address in writing within 4 days of your moving. If you don't move, we'll address this further on March 30th at 2:35. And if legal aid is going to come in and represent you, so be it. This is a month-to-month tenancy. It looks like they were trying to get a lot of people out of this place. I think there's 6 rooms in this building. I don't know all the details of what's going on. If you just move and turn in the keys, they could perhaps even dismiss the case, which wouldn't show as evicted on your record. So you stay in contact with Ms. McNary. If you move, turn in your keys. If you don't, we'll have a hearing on March 30th at 2:35.
Yep, I will be moved.
All right, thank you for your patience.
Thank you, Your Honor.
All right, thank you, Mr. Duckett. Ms. McNary, I'll see you again. All right, I'm going to stop the live feed for a few minutes. Our next hearing is at 10:50, so we got about a 20-minute break here. So we'll deal with her in a minute. All right, we've got 2 Richmond cases. Terry and Larry Richmond versus Marcia Merriam. Marcia Merriam is present. We were here last on March 13th. This is filed as a termination of tenancy case on a month-to-month tenancy. The plaintiffs want the defendant to move. Ms. Merriam, what's your position?
Well, right now I'm looking for a place
All right.
because I'm disabled. I'm disabled now, so it's kind of hard for me to get around to find places.
Yes. And most of the places are non-smoking. If you were going to get into any subsidized place, they would be non-smoking. Well, this is our second hearing. You had indicated you were checking on a new place at Millard Court. But right now, you have 10 days to vacate, which would be March the 30th, or you're subject to being evicted. The written, you also have till March 30th to appeal this. The Richmonds do not have to evict you on March 30th. They have 56 days from today to ask for the writ of eviction.
Lydia, did Safe Built give you a time frame?
They, last I spoke with them, they were wondering where we were at with the eviction process. I told them that we had court again today. As far as I know, they originally gave us 30 days, but they extended it because of we're going through the court. 30 days.
What are you referring to?
They're going to post it, condemn it if she does not move out. So they gave us 30 days, but we asked them to hold off so that we could get her to move, give her time to move. That's why we filed the notice for eviction. So.
All right, Miss Merriam, you got, the city is about to condemn this, which isn't good. It failed inspection and they want to bring it back up to code. And they started this process with a notice to quit quite some time ago.
January.
Back in January. And so you have 10 days to move or you're subject to being evicted. You do have 10 days to appeal this. I think Miss Bauer was here, but she's not here now. But at this point, they're under pressure from the city to have this property vacated. And Here is Meg Bauer. So you have 10 days to move or you're subject to being evicted. So you should work on that property at Millard Court. Now, when you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. All right. Do you have any other questions?
I'm just trying to find people to help me move, and I'm not having no luck with it.
All right. I wish I had maybe you try with the city. The city is the one that wants this vacated. All right. Good luck to you, ma'am.
Thank you,
That's a tough
Your Honor.
situation.
It
All
is
right, we got
terrible.
one more. We got Richmond versus Dustin Shepherd. It's a damage hearing. It is 11 o'clock.
You don't need me for
This
Terry.
I don't
is
think
file.
so. Thanks.
This is file number 252384LT. Terry and Larry Richmond versus Dustin Shepherd. There's a claim for damages. Ms. Richmond, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
I recall this case, and Mr. Shepherd, excuse me, that one sneaked
Bless
up
you.
on me. That's the last one. You've provided a security deposit notice, and you do an excellent job of these.
Thank you.
And your amounts you charge are fair and reasonable. But let's start with the amount rent through December 20th is $2,384. Is that correct?
That's correct. And 28 cents, but
28 cents. Repair 2 broken window screens, $40 a piece, $80. Clean bedroom carpet, $40. Touch up paint, $50. Labor for cleaning and installing a front door and new carpet, $320. Replace solid wood front door, $180. So the total damages are $3,054.28. Is that correct?
that's correct, sir.
Elaine, do I have a judgment in here?
Oh, you might not have. I might have
I don't
forgotten.
see.
It's
maybe
just a
Elaine
civil
could-
judgment, right?
Yes.
I'll get one
All
to
right,
you.
well, let's, then there's security deposit of $975. So if we take damages minus the security deposit, we get $2,079.28. Is that correct?
That's correct.
We got court costs of the writ, $157.13. Or $157.13, the writ of $15, Southwest Legal, $38.39. Let's add that up. 157.13 plus 15 plus 38.39 is 210.52.
Oh, I got 2274. Let me check.
Well, let me try it again. 157.13 plus 15 plus 38.39. 210.52.
Oh,
plus 207.928. I got a different number than you got.
okay. What'd you
But you
get?
got 157.13, writ 15, Southwest Legal 38. Did you leave something out?
I don't think so. So you came up with how much? 2000?
38.39 is 210.52.
2000.
All right, so we had
Oh, that's the
210.52
difference.
plus 2,079.28.
Oh, I see what you're saying. So my judgment should be 2038.39.
It should be 2002, 2,289.80.
Okay. All right. I'll just, oh, that's higher than what no, it's not.
It's not, it's 2,289.80.
Okay.
All right, if you'd send that, we'll sign it and
Okay, I'll have Lydia drop one off.
all right, thank you, Lydia. All right, thank you. We're
Thank
gonna
you, Your Honor.
show as a default. Plaintiff will provide judgment. All right, enjoy your Florida Keys Day. We got a ways to go yet here in Michigan. You missed a bunch of snow, and you also missed the tornado.
I
Did
know.
any of your properties get damaged?
You know, for as many as we have, we fared very well. I think we had like maybe 4 trees on roofs, and they're all repairable. So it's just getting the trees taken down and getting the roofs repaired, and we're on it. So
Well, you're in for a surprise when you come back.
I saw some pictures.
Yes. All right. Thank you. And
Thank
I'll see you
you.
next time.
All right, thank you.
All right. Next, we got Sturgis Housing Limited versus Sheldon Ashbrook. And I don't see anybody here on that case. That's set for 11.
I'm
We'll
here
set
for that.
Yeah, we don't, the attorney isn't here. No, Mr. Popovits is here. And then we also have Enchanted Glen versus Cleveland. It looks like the Sturgis Limited is going to be a default. Miss Cleveland is here. Mick Bauer is here. Let's call that case. Enchanted Glen versus Roche and Cleveland.
Hello, Your Honor.
Good morning. Manager from Enchanted Glen is also present. All right, this case has had several hearing dates. I got 4 pages of notes. The defendant was working on vacating, I think, and the parties were working on perhaps a conditional order of dismissal. Mr. Popovits, what's the status here?
Thank you, Your Honor. I appreciate the court scheduling of this matter on a weekly basis, given the obviously the circumstances. Ms. Bauer wasn't here last time. She had a colleague from her office subbing in. There was a significant amount of discussion as to rent, arguments as to, or not even arguments, but testimony that was elicited from the court from the tenant and from the property manager as to processes involved as to assigned application and anticipated recertification, the status of that application. And we started discussing possible conditional dismissal terms regarding the tenant's vacation. If this tenant was to be vacating, then my client would be far more agreeable or flexible as to agreements as to rent amounts and things of that nature. We got to a point where I believe Ms. Bauer's colleague was a little uncomfortable. He had not had many conversations with the tenant, was just subbing in as a good coworker for Ms. Bauer. And I think that it got to a point where he wasn't comfortable sort of agreeing to a conditional dismissal or anything of that nature for the lack of understanding of the circumstances. Ms. Bauer is back today. We have not talked prior to today. I did try to reach out. I know Meg's probably very busy. I'm wondering if a breakout room could help for her and I just to sort of see what update she's received from her client as to possible vacation. And if that allows us to cut short some of the anticipated testimony regarding rent amounts, processes, things of that nature, I'm not willing to meet.
All right, that's fine with me. Meg, what's your thought regarding that?
I just want to clarify a couple of things. First, Judge, there was no testimony taken. No one was under oath at the prior hearing. I also would, I don't have a record of Attorney Popovitz reaching out to me. If I missed that, my sincere apologies on it. But one thing that was not discussed very clearly at the previous hearing was that the plaintiff filed for a money judgment in this case. And so simply swapping or consenting to possession, I thought Attorney Roberts, managing attorney, filled in on my behalf, made a good point about not just entering a number, because if this is a non-payment of rent case, the tenant should have the opportunity to redeem, but also in my review of the file this week, we requested the tenant file, and we did not receive the entire tenant file. So there are a lot of, I'm certainly not opposed to speaking with my colleague in breakout session, but I would actually request permission to view the file on the premises, because it is unquestionable to me that the file was incomplete. I have records transmitted by the plaintiff to my client that were not included in the transmission to me. And so at this point, I don't know what's being taken out selectively or not, among some other concerns. So I'm certainly happy to meet with Attorney Popovitz and discuss this. Of course, the goal is resolution and to not waste the court's time. However, there are additional. This case is not as simple as meets the eye, and quite frankly, Ms. Cleveland doesn't have anywhere to go. This is subsidized housing. The subsidized complex has a duty to the tenants to do things right. And based on my review of the evidence, which if we go that far today, I am fully prepared to demonstrate. Not fully prepared, I am prepared to demonstrate, but the complex has not done things correctly here. And so we've got a terminally ill individual who's going to be homeless as a result of this. And we've got Ms. Cleveland, whose future is also at risk here.
May I, Your Honor?
Yes.
I've got an email, Meg, that I sent to you on March 18th at 10:32 p.m. asking you to reach out to me. So I'm not putting things on the record that aren't accurate as to my attempt to reach out to you prior to today's hearing. Agreed, there was no testimony. There was a lot of questions and answers, and that's what I was alluding to. The court did a very good job of filtering through the issue and trying to get information from both of the parties. So while there was nobody sworn under oath, I'm not trying to characterize it in a way that's not the way it occurred. You had a colleague here who I thought did an exceptional job standing in, but it got to a point that there wasn't a comfort level as to any agreed upon resolution regardless. And I get the money judgment, and I get the fact that he didn't feel comfortable with slapping a number down because he wasn't fully versed in the defenses and the potential defenses. That's why there was stakes pulled. And quite frankly, I was as involved as anybody in pulling back so nothing was entered discourteously towards you or your client, because I was the one who made the representations to the court that you should be here given your knowledge. I don't know that there was anything not included in the file. I'll send you whatever we have. It may have just been in a different, it might be cell phone communications or texts, and those aren't typically kept in the file. With you, I sent you the file. It was available for your client. We'll get you whatever else you need. Let's not overcomplicate this. And Ms. Cleveland is the one who continually has told my client or the court, represented to the court, that she's vacating. So any opportunities here for a quicker resolution and an amicable resolution as to an amount of rent that would be due and owing under a money judgment and a conditional dismissal for her to vacate is not the complex's doing of pushing or trying to make somebody homeless based on anything other than the legal proceeding in front of them, but based on her own commentary and actions on site that show she's trying to move. If she doesn't have anywhere to go, then she should stop saying to other people that she's moving, so we're not confused or thinking that's an option. And if we need to get you additional documents for a testimonial hearing, fine. But this is a non-payment, so ultimately we could put on testimony. The judge could figure out an amount that's due. She has 10 days to pay it, and she'll be evicted. I, above anyone else, try to work these things through a global resolution. I'm a little taken aback by the courtesies I showed a week ago and then sort of the demeanor here.
All right, stop. I'm not gonna put you guys in a breakout room because you're not gonna accomplish anything. You're just gonna snipe at each other. And so let me finish the default case. I had to be in Kalamazoo by noon. It ain't gonna happen. So we'll see what we can accomplish, but I don't think I'm gonna accomplish anything by putting you in a breakout room. So, Mr. Popovich or Ms. Arnold, would you join us, please?
Judge, can I just make one brief statement
No.
that I think is positive? Okay.
All right. Well, if it'll be helpful, fine. If you want the last word, then so will it help?
I just wanted to let Mr. Popovich know that I don't have any personal beef or frustration with him, and I appreciate his collegiality. That's all I wanted to say.
All right, fair enough. You guys have worked together on a number of difficult cases, and maybe we can get there on this case. Let's take up Sturgis Limited Housing versus Sheldon Ashbrook. The file number is 251782LT.
Thank you, Your Honor.
Attorney Rebecca Arnold is here.
Yes.
And good morning.
Good morning.
P72714.
Yes, that's correct, Your Honor.
And the manager at Mystic Grove is here. Would you state your name?
Cynthia Graves. I'm here at Gateway. Sorry, I couldn't figure out how to take the Mystic Grove off of there.
All right. Cynthia Gaines.
Graves.
How do you spell that?
Graves.
All right.
I'm the assistant manager here at Gateway.
Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right, Ms. Arnold, you've submitted an accounting. Mr. Ashbrook is not present. You're claiming, and Ms. Grove or Graves, I didn't spell it right. Anyway, that's close enough. Rent May, June, July, August, September, and a partial for October. The rent component is $6,748.
Yes, Your Honor.
Is that your intention? Cynthia, do you agree with that?
Yes, I will agree.
You've got late fees of $300 and damages of $471. Is that correct?
That is correct, Your Honor.
So if we had late fees, rent, and damages, I gotta redo this a little bit. 6,748 plus late fees of 300 plus damages of 471. We get 7,519.
That is what I have as well.
Now, do you agree that the security deposit would be 1,301.73?
Yes, that's also what I have.
Equals 6,217.27 in damages. Now, if we add court costs of 414 back in, we get 6,631.27, which is the same number you had.
Yes, my math is the same.
6,631.27. And that's the amount that you're swearing to under oath is due and owing in this case.
Yes.
Ms. Arnold, I don't see a judgment in here. Could you send?
Yes, for the money judgment, I can send that. Yes, Your Honor.
All right, I grant money judgment in that amount. We came to the same number a little bit differently, but damages of 6,000.
6,217.27.
Yes.
Okay.
6,217.27 plus 414 in court costs for a total default judgment of 6,631.27. $661.37. 6,631. Plaintiff will submit judgment. The easy part is getting the judgment. The hard part is getting any money, and this defendant probably is not very collectible, but you can send that to our email address, which is on the pleadings, 3bcivil@stjosephcountymi.
Okay, I'll do that this afternoon.
All right, thank you.
Thank you.
All right, we've cleared the decks. I was hopeful. I set these two things closely together, and I was hopeful to get out of here this morning, but we're going to be here for a bit. So let's call Enchanted Glen versus Mary Cleveland and William Roche. Mary Cleveland is present. Is Mr. Roche also present? Where is he?
He's in Three Rivers. I'm thinking he didn't get a ride back home last night. Couldn't get a ride.
Three Rivers where?
I'm not sure. He had to take the U-Haul back yesterday, and then he had to try to find a ride back home.
All right. Is he moving stuff to Three Rivers?
Yes. Well, we have a locker in Centerville, actually.
All right. Also, the manager, Kim, is here. Would you please unmute your microphone?
Hi, Your Honor.
All right. Good morning. Miss Cleveland and Miss Snow, would you please raise your right hands? You will swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Absolutely. Yes.
All right. We've been at this since March 6th. We adjourned it from March 6th to March 13th and March 13th to March 20th. The plaintiff's allegation was that through March, the rent was $4,362, $313.45. In court costs were a total of $4,675.45. We spent some time last week trying to get to that figure. As I've said, no one was under oath. Mr. Roberts was here. Mr. Roberts has plenty of experience in this area, but he didn't have experience, and he was unwilling to make any final decisions because of that. So as Ms. Bauer indicated today, there are a number of issues regarding recertification times and that sort of thing. And there were issues about William having income. William isn't here, which is not helpful because he's one of the defendants here, and he is also one of the sources of income. Ms. Cleveland, would you raise your right hand? Oh, I just did that. I swear you both. And as Mr. Popovich indicated, the defendant was in the process of trying to vacate which makes the dollar amount less crucial if we don't enter a money judgment. Let's say, like say you owe $1 million in rent, or you have to move out, and you move because you're not going to pay $1 million in rent. I didn't make a finding that you owed $1 million. We would have a hearing. Let's make it more realistic, $10,000. We'd have a hearing at some point regarding how much money you did owe. This is set for both of those things. And so Mr. Roberts, I think, was reluctant to enter into any sort of agreement. So let me ask this, Miss Cleveland. You're in the process of moving your stuff. Have you found anywhere to move to?
No, I've tried, and I've called everywhere that every resource, every department. There are some.
That's
Go
why,
ahead.
Judge, that's why this matters more than just a possession judgment, because when she applies for additional housing, the first thing they're going to do is ask for references. That reference is going to be the prior landlord, who's going to then have to speak to the status of the account. So even if she consents to a possession judgment, that still dooms her ability to get future housing, even if there's no eviction judgment on her record.
All right.
That's why I'm digging in.
From your perspective, how much do you believe the rent is?
It appears to me that the rent should have been $224 for the first from June until this apparent recertification effort for $212. Based on documents provided by my client and the same document provided by the plaintiff, there is a form, it's a rural development form 3560-8. It's a summary of the tenant's recertification. In that form, the tenants are indicated at the income level of very low income, which is the highest priority by federal statute for receiving rental assistance. And yet, on the second page of that summary certification, they don't follow the process flow correctly. If the tenant receives rental assistance, enter line 28 on line 31 below. That box is checked, but then line 28 is not entered on the line below. The reason for that does involve Keystone, or apparently involves the presence or involvement of Keystone Place. But at no point in time were the tenants.
Well, I didn't ask you all this yet.
Okay,
I just asked you how much you believe she owes.
Explain.
So you believe $212 from June?
224, Your Honor.
All right, from June to
arguably the present, if there's not been a new certification, but it seems that there was a rental adjustment. There was nothing in the records I received, but that was elicited at the last hearing that there was a gross rent change in December or something like that. So that would change the rental rate. And then there was this attempt in December starting in January.
All right, I'm just trying to figure out how far apart we are. So 212 from 224 from June to when?
At least December.
All right, so that's 6 months. 224 times 6 is 1,344. 224 June to December, 6 months equals 1,344. All right, then if we go forward from December to January, February, and March, what do you contend the rent is for those periods of time?
Based on representations from my client, $212. Absent any change in documentation, it would still be $224.
All right, so 224. All right, 224 times 3 is 672.
And that doesn't account for any payments that have been made.
2016. So do you contend payments were made?
Keystone Place paid $1,083 a month for 6 months.
After June?
Yes.
Starting in June.
I can break Your Honor, just looking at the ledger, I can give you the payments that are reflected in the ledger, so they're not contested.
All right.
All right.
Payments were what?
So payments, so here I'll go through this. Payments since June 1st are $1,083 on June 10th, $975 on June 10th, $34 on July 1st, and then also on July 1st, $1,083. And then there are 4 other payments of $1,083 that were made on August 1st, September 1st, October 6th, and November 10th.
All right, so during the period defendant contains the rent is $212. Someone other than the defendant is paying $1,083, give or take, all the way through November.
Correct.
All right, so 10/6, 1053. 1053 times 1, 2, 3, 4, 5, 6. $6,318 plus 975 plus 34, 1009.
So, Your Honor.
Just a minute. Just a minute.
Sorry.
All right, 7,327. All right, so that would pay the rent through November. So what appears to be at issue from Enchanted Glen's position is the rent is December, January, February, and March, I think is what we calculated last time.
Yes, I can give you that total.
All right.
That is $4,372 based on.
I thought we had 4,362.
Well, there's been a $10 late fee that must have been in there. That
all right.
Maybe wasn't it should have been last week too, but it hits on the 11th. We should have been here, but so yeah, and that's at 1,083 for December, January, February, and March with $10 late fees. The account is, I mean, just to clarify, the account is based on the ledger that I just sent Ms. Bauer as well. The updated there, it's current through November. So there's a zero balance as of November 10th. And then the balance forward for those months that you've identified is $4,372 and through March 11th or through today.
All right. So the fundamental disagreement is defendant claims rent is $224 and plaintiff claims the rent is $1,083. And the rub happened, according to Ms. Cleveland, they thought Keystone was going to pay the rent for 18 months and Keystone stopped paying the rent as of December 1st.
The other option or the other part of this though, Judge, is that the defendants would have accepted the rental assistance in the permanent subsidized housing had that been properly communicated. So the idea of the rapid rehousing program is to get people established into stable housing. These tenants were eligible for rental assistance and should have been put on that program from the jump.
All right, so who failed to do that?
At this point, I would say that falls on the property manager. If I may share my screen, I'd like to demonstrate where I'm getting this from. I'm not just making this up, I guess.
All right, go ahead.
I have redacted the personal identifying information from these documents, Your Honor. So this document here is the form 3560-8 that I referenced. It is, can you see my cursor or no?
Yes.
Okay, so it is indicated to be the initial certification for move-in. You see the tenants are listed as household members. The calculations here, what I was referencing, if the tenant receives rental assistance, enter line 28 on line 31 below. You see this box is checked. And I have to move you guys out of the way here. I apologize, this does have my notes on it, but if tenant receives rental assistance, enter line 28 on line 31 below. So line 28 here is 326. Line 31, you see that number is not entered here. 326 is not entered. There's a deduction for the utility allowance, which gets us to the 1,083. Where this matters is because up here, the current eligibility income level is V, and V stands for very low income. And that is the first priority under the rural development regulations for rental assistance. These properties have a rental assistance tenant selection plan. And Keystone shouldn't be paying $1,083 when these tenants are eligible for rent and able to pay $224. And that rent, that assistance.
Who made that calculation? Is that your handwriting?
That's why I say I apologize that I wrote on here. That's me.
All right, but so where do we get that figure?
So if you follow how the form is supposed to be filled out, if tenant receives rental assistance, they're very low income, they're eligible for rental assistance. Enter line 28 on line 31 below. Line 28 is right here. And line 28 is 326. So the number that should have gone on this line is 326. But instead, the number that went on this line is 1,185. Which gets us to the final NTC, that's net tenant contribution, also known as tenant rent, essentially, the tenant portion of rent. So here, they've determined that the tenant rent is 1,083. That matches what we see on the ledger. The problem is, this form is filled out wrong. 1,100.
Well, at this point, you're testifying as an expert, or guess, as to what should have been done. I'm not saying you're wrong, but, and I'm sorry, Ms. Shaw, I called you Ms. Snow. What's your response to their contention that the form, would you scroll back up a little bit, Meg?
Yep.
Wasn't down a little more. A little more, all right, right there. All right, we got part 6 and part 7 and part 8. So according to this, rent is $1,083, which is what was charged, and Keystone was paying it. Their contention is that this wasn't calculated correctly. What's your response to Ms. Bauer's representations that she just made regarding how it should have been done.
Your Honor, to begin with, Keystone will not help people that get rental assistance. They pay the whole amount of rent. So if I was to have given them rental assistance, Keystone will not pay it.
Correct.
So at the time.
So if someone has a subsidized rental rate, Keystone won't pay it because there's an assumption that they're already receiving enough assistance, and Keystone pays rent for people that are not subsidized. Is that correct?
Correct. And once I get this information, I send their packet to our compliance department and corporate. They fill this out. They send this, they put this in the computer, and I print it out. I don't know what their rent is until after the fact, until I get it on my end. And that's what Keystone, that's why their rent was $1,083. In January.
And Keystone paid that for months.
Yes.
And then at some point, Keystone stopped paying the rent?
They stopped paying the rent. I do believe, if I remember correctly, would have been December 1st. Was their or November 1st was the last rental payment from Keystone.
All right. So once that happened, should the defendants have had a recertification?
Yes, they should have. And they started to come over and they filled out the application portion of it, signed all the application part of it, but they never came over and finalized it by signing their lease, their current lease that they would have had after signing the application. In January.
All right, there was some discussion of that. Now,
yes.
And Judge,
okay,
I don't have any of that.
I'm not allowed to send that completed because I was talking to my boss and they said, do not send anything that is not completed.
Okay. So they don't get to double dip. They don't get a subsidy and then Keystone pays that subsidized rent. It's either all or nothing. So Keystone, and Miss Cleveland's representation is they said they were going to pay for 18 months, but at some point they stopped paying. So Mr. Popovich is correct. The rent is paid through November. So we're talking about December, January, February, and March. Ms. Bauer calculated at $224 per month. Your testimony is different. The bigger question is whether they should have been recertified, not whether the rent should have been $224 per month, because it was $1,083 through November.
Except, Judge, I don't have anything. I have documents I have manager Kim Shaw, and I have a representative from Keystone signing documents that the tenants are being placed in this program, but I don't have anything showing that the tenants have consented to this or were given an opportunity to get on the permanent rental assistance program that they were eligible for and trying to get into.
Well, that's what we're trying to determine.
I mean, back in June. I mean, not getting.
What do they care? They got $1,083 worth of rent, and they didn't lose a penny. Keystone may have been out $1,083 if rent should have been something different. But if their rent, they're better off with if it was subsidized, they would have had to pay that rent. From June, July, August, September, and October, and November, and they paid zero.
Yeah,
Keystone paid it all.
Judge, there's two reasons. One is dignity. Like, a lot of people think that subsidized tenants ride and abuse the system, but actually a lot of my clients prefer to have the dignity of paying their own rent. Second of all, and I'm sorry, Judge, second, Keystone is a temporary program intended to transition people into stable housing. the golden goose is to get rental assistance. That is the goal that tenants have when they move into subsidized housing. So they do care, because if they were on that program, we wouldn't have had this sudden pulling out from under them of the sheet, or pull it rug. I don't know where sheet came from.
Well, I don't think they have any damages, but dignity is hard to put a dollar figure on, and it wasn't done. And I don't know why, but we now know that the Keystone subsidy was expired or removed or canceled. The defendant's contention is they came in and thought they had recertified. Ms. Shaw's contention is they did not. So we need to figure out now right now, according to plaintiff, they did not complete the recertification process. Keystone stopped paying their rent, and they contend that they owe, why don't you give me my screen back? We got this random stuff scrolling on the screen. $4,772. If you're now, I don't have a witness to tell me what the calculation should be. You calculated it, but you're the attorney. So even if I use your figure,
I can do this through an adverse witness from the property management company.
Well, I'm not sure she could answer it that way, but
I don't think it's fair to spring these exhibits on Attorney Popovich without him having a chance to discuss and see them. I've got a couple of other exhibits.
Well, there are exhibits that are in his possession also, but what I'm trying to avoid is a 2-day trial on this. I have to be in Kalamazoo at noon, and I'm not going to make it. I was hopeful you guys could get somewhere, and you're not anywhere. So we're fighting about the difference of about $2,000. The farther we get behind, the less likely is the defendant's going to be able to pay the entire rent. Keystone's no longer paying the subsidy. Even if we do it at a subsidized rate, we'll be into April. It's going to be about $3,000, give or take.
Subsidized rate, Judge?
So
it would be about 800.
Well, I guess about $800. 224. That's your calculation. I don't know what it really is.
Right. You said at the subsidized rate. So I just
at that rate. So
it's 1120. Yes. It goes through April. At the 224, or whatever that rate was, it'd be 5 months. Remember, we're talking December, January, February, March, and then April. We're not into April yet, but for purposes of any continuation, it's about 1120.
Sure.
Plus the court costs and the other amounts.
Yes. Well, if you'll agree to that, we can use that figure right now. But I don't know that you're in a.
Well, Your Honor, may I have a chance and I don't want to waste your time, and I know you have to travel. I don't want to.
I'm already not going to make it, so. Go ahead.
I appreciate the way you're handling this, and I've been sitting here letting Ms. Bauer testify and argue and commingled, and that's fine. I respect her, and I think she has as good a handle on these forms from an adversarial standpoint and an advocacy standpoint as anybody. But I agree with Your Honor's take on, dignity aside and all these other things. These folks haven't been damaged. They had $1,083 paid for them from June till December or till November. And the issue of whether that was more than what should have been charged is between Keystone and the complex, if there's any issue there between them. And I don't know that there is. I have no knowledge as to that. And then, quite frankly, my guess would be if really we wanted to unwind the ball of yarn, $1,083 goes back to Keystone, and then $224 is charged to Miss Cleveland, who's then another 6 months behind in rent added to the December through April, so that doesn't put her.
Yeah, they're worse off if we went in that direction.
Right, they're worse off. Plus, Keystone's not even a party to this, and I don't know how we articulate or even handle the lack of presence as to there's no claim for the return of the 1,083 or any claim from Keystone against the Miss Cleveland and Mr. Roush for the overpayment or against the complex. However, Keystone may preface that type of issue. If here's one concern. I don't know that these folks can even, and I'm not saying this disrespectfully, but I think that 224 for now 5 months plus the court costs, that's a significant amount of money, and they'd still probably likely need some assistance to come up with all of that. And there's third-party agencies that may help them. I'm not adverse. The
third-party agencies won't help them if it's a subsidized amount.
So
they're not going to be eligible for Keystone or DHS or the others. That's either money they're going to have to pay. So if you agree to that number, we can use that. But I'm not sure at this point you wish to do that.
I'm long-winded, and I apologize because I'm getting to that issue. I wasn't aware. I think some other counties, the DHS might help if there's subsidies, but I defer to you and Ms. Bauer in that regard as to this area. But I'm not adverse to having a private conversation with Ms. Shaw, talking this through and making a decision as to the 224 to avoid sort of this length and the cost associated with Ms. Bauer's dissection of these forms and sort of the argument as to, is the application indicative of a recertification, or because no lease was signed, it doesn't process.
I'm going to open 2 breakout rooms. I'm going to let you talk with your manager. I'll let Meg talk with.
May I
go ahead?
One last thought, just because it's pressing, and something for your honor to consider, plus Ms. Bauer. We don't have a completed recertification currently. So we from policy standards, whether Ms. Bauer believes that's correct or she wants to make accusations as to mishandling or anything else that she's likely to do, and it's kind of insinuated, we don't have a completed recertification form and lease. So if we agreed to those figures just for the purposes of this 10-day order to get possession and payment and to figure out the possession action as currently prefaced with the court, we have this issue starting in May as to what or maybe April if it was today, because we're not.
It would be April.
It's April. What's the rent? And we're going to still have it at 1,083. This is why I enjoy conversations off the record between hearings with Ms. Bauer, because we try to work a global resolution that avoids those sort of secular arguments that continue to kind of reform every cycle. So I'll talk to Ms. Shaw and I'll get some feedback from her and we'll come back. But I wanted to put that out there that, equitably, it's not within the court's power to force the recertification at this point based on the preface of the pleadings in front of it. But if there was any tolerance for this amount just to be done with this, I won't say anything crass, but these arguments as to the amount and what amount it is and whether or not it's irrelevant or a relevant point, we've got to address that as well, both with Ms. Shaw, but then also with these tenants.
All right. I'll put you, it's not your fault. I'm missing a luncheon program and an afternoon program, but we'll get there when we get there. They're going to start without me. All right.
While you're putting those rooms together, I just want to point out that this speaks exactly to the bias that my clients often face, which is that this whole conversation, the presumption has been that my clients can't afford $1,000 to keep their housing, and that they will be requiring public assistance, and that's just not always the case. Also, the damages that my clients are experiencing are this massive risk of homelessness that so it's more complicated. It's always
more complicated, but in point of fact, no rent has been paid since December. Enchanted Glen has a waiting list of people that are homeless that would like to rent this apartment.
These guys again.
So there are always multiple sides to every story. I don't know if we're going to accomplish much here, but I'm willing to give it a shot. I'll get there about 3 o'clock. Let's see what we got. Add a room. All right, assign room 1.
Gary, before you go in there, I still don't know what my clients actually would need to provide your client to complete this recertification. I've looked at the correspondence I've received, but there's nothing in writing about what they still need to do. So
Kim, you're sworn in. Thanks, Meg. Kim, you're sworn in. Why don't you just articulate without giving more than you're comfortable, but share with Meg what these folks would need to do to complete the recertification.
They would have to reapply because their paperwork is more than 90 days and compliance department won't take anything over 90 days. So they would have to refill out their application and give me all their income, all their banking information from both parties, him and her.
Okay. All right. Fair enough. Thank you.
Yep.
Don't understand what was missing before then, but you and I can talk about that later. Jerry.
Well, and I guess, Meg, remember, they didn't sign the lease. There's policies, and I understand your take, and I understand your equitable arguments that you're making, and you're a heck of an advocate for these folks, or all of them that come through. But if they don't sign the lease and they don't complete the process pursuant to the policies, listen, I'm not here evicting every tenant in Enchanted Glen. I'm here evicting certain ones that don't comply with the process. And so if they didn't sign the lease, we're not picking.
I wasn't trying to reopen the debate. I was just trying to let you know the things that I was looking for while you're talking to your client.
All right. Okay, Mr. Popovich, I'll put you in there with Ms. Shaw.
Thank you.
And then room 2, I will assign Meg Bauer and Mary Cleveland. Miss Cleveland, hit the button that says join. All right, Miss Cleveland is back. Meg Bauer is back, and the plaintiff and manager are back. Mr. Popovich, you had an opportunity to talk to your manager, Ms. Shaw. What's the plaintiff's position?
Your Honor, we've talked. I have an amount of respect for Ms. Bauer, but I have an admitted lack of, I think, patience in some respects for these arguments when a non-payment turns into a complete breakdown or analysis of the recertification. And I've made my peace with that in the earlier comments that we're not evicting every person. So there's not a failure in the process, but some people haven't complied and then there's consequences or ramifications. That being said, I had a wonderful conversation with Ms. Shaw. She understands. Her and I both work for higher ups in management at TM, but we're both comfortable putting this on the record. I would agree to resolve this with agreeing to the 224 rent due from December, January, February, March, and April. And I'd give them until the last day of April to pay that amount and have a full recertification process completed and accepted by TM or by Enchanted Glen. And I do that because I find that tenants who put themselves in these situations can benefit from not only the advocacy of legal services, but the assistance of legal services to help with the recertification process. Ms. Shaw, whether Ms. Bauer likes to like the answer or not, says that everything needs to be resubmitted because it's 90 days past due. We do answer to these subsidies. We have certain things that have to be done in accordance with the timelines and the current the documentation has to be current. So where we would want is the last day of the month is April 30th. It's a Thursday. By then they've paid all of this rent at $224 per month plus the court costs, and they fully recertified, and we can move on. And I will deal with the internal communications to TM as to why they're only getting $224 a month versus $1,083 a month as to these months in question. There cannot be today or any day in this court case, based on the filings and the pleadings as currently situated, a determination of the recertified rent amount. It may not be $224 as Ms. Bauer has calculated because the information has to be resubmitted. But this is her opportunity, and she can certainly utilize my openness to communication throughout the recertification process to address any concerns she has with TM's corporate compliance as to the calculations, or help her clients to make sure that current documentation and appropriate documentation is presented so they get the most subsidy that they can possibly get. It'd be a global resolution, and one way or the other. And if they're not able to comply and they don't like the rent after that, everybody's still bound by leases and Michigan law. But this is an opportunity to not spend any more time in court testifying over rental subsidies, assistance, what should have been done, what shouldn't have. This is a non-payment case, and conceding the rent for those months and giving them the buffer of April to complete everything, moving forward with, by then, a well-informed decision as to what May's rent would be, seems like an appropriate opportunity, and it does save somebody from becoming homeless without having their day in court. I apologize for going on and for any tone that I may have taken, but this is the opportunity that I think presents itself based on the openness of these discussions and what we're willing to do going forward.
All right, Ms. Bauer, what's your position regarding that?
I think that that's generally a very fair and reasonable offer. I did, as we were being pulled in here, send a different offer to Attorney Popovits. He may not have had a chance to see it or not, and he may not agree with it. I think it's a fair and reasonable offer if his client is willing to make the adjustment to the final account to reflect those numbers, and so that if there's no going backwards and undoing, that it's not just for purposes of possession. I think it's a very fair offer.
All right. Now, then they're going to have to get recertified during April and late March. But it is very generous because it goes all through the month of April. So I find 5 times 224 is 1,120. We previously determined that court costs are $313.45. That leaves us with $1,433.45 due by April 30th.
But of course, Judge, I don't know. I guess I had sort of put a condition on that. I don't know if about the account actually being changed to reflect.
Well, I don't. What's your response to that?
Can that be explained to me? What are we looking at?
No, I don't need it. This is my ruling. I'm going to accept your generous offer if it comes to a money damage hearing and they're going to claim that 1,083 is due and owing. In the unlikely event, we'll determine it at that time. Well, Ms. Cleveland, you've got until the end of April to pay $1,120 in rent and $313.45 in court costs, which is $1,433.45. You also need to go in and complete the recertification process. I don't know what your rent would be. There was an allegation that Mr. Roche had some income, and he needs to be here. He's sleepwalking through this. You're here, your lawyer's here. He's not here. He's a party to this, and his income is relevant. Now, he may have some illness and some other things I don't know about, but he does have Social Security, perhaps other income, a pension or something that will need to be calculated into this. But I find that you have 10 days to appeal this, Mr. Popovich, which would still be the March 30th date. The rent due date is April 30, 2026. The rent is $1,120 and the court costs are $313.45. So the defendant now has 40 days, March and April, to pay the rent and get recertified or move out. You may decide you want to use that $1,400 to move into another place.
That's why I was asking the account question, Judge.
Well, they're not suing for money damage.
They did sue for money damages, Judge.
This is not a money damage hearing. This is a possession hearing. So if they pay the rent, they get to stay. If they move and we have a hearing regarding money damages, in that unlikely event, we'll determine it at that time. So essentially, Ms. Cleveland, you got what you asked for. Ms. Bauer has vigorously argued that your rent should be reduced to $224 once the subsidy ran out, and the plaintiff has agreed to that. The court costs will be the same no matter what. Now, my belief is if this is a subsidized rent, that you're not going to be able to get assistance from Neighborhood Inc. or Keystone. You can request it. You'll get a copy of this judgment, but I don't think if it's subsidized, they're going to additionally pay it. But I may be wrong on that, and different agencies may have different standards. I know Neighborhood Inc. doesn't pay for subsidized rents. So I don't know if you've got $1,433 that will pay your rent. That would be great. May 1st, the rent is going to be something different. You'll have to sign a lease. You'll have to agree after the recertification process what your rent is. If you're eligible for a subsidy or if you're not, as of May 1st, it will be different. If you pay this, then May 1st will start fresh. If you don't, you're subject to being evicted on or after April 30th. You can certainly discuss this further with Ms. Bauer. You and Mr. Roche are going to need to get in with all of your documentation and start the process to be certified to stay at Enchanted Glen under a subsidized rent. And your lawyers both spoke to this. If you get evicted, it's going to make it difficult for you to get in anywhere else. But the plaintiff has folded their tent and given you what you asked for. But at some point, you got to pay some rent. No rent has been paid in the last 4 months, and the 5th month is coming up. So hopefully between you and Mr. Roche and your sources of income, you can pay that. But it's incumbent upon you to get with management and get a recertification. Mr. Popovich, I'd ask you to email me a judgment in that amount, $1,120 rent through April 30th, court costs of $313.45. For total possession only judgment of $1,433.45. The appeal date is still March 20th.
And I will put the payment due date by April, the last day of the month of April. And I don't know that the further order section has to articulate any specifics as to the recertification, but I think that's well established that this isn't a concession moving forward. It's an economic concession to solve this problem. And
yes,
certainly they behoove themselves to complete the recertification process. They don't like to pay me to be involved in the recertification process, and I understand that, but I am offering my very affordable and economic assistance in the sense that if Ms. Bauer likes to reach out to me or needs to reach out to me to assist these people, I will act as a go-between and not become a problem for either my client or them in the sense of helping with the relay of information. I would like to see a global resolution here. And I appreciate your Honor's take and handling of the matter. And I appreciate Ms. Bauer's assistance and advocacy. And I remain open to communications to help her if she has any questions as she helps these folks through the recertification process.
Now, Ms. Cleveland, you've already started moving your stuff out of there. If you just decide with Mr. Roche, you're just going to move before April 30th. If you just decide you're going to move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving out. I'm not determining how much money is due at this point. So if there is a hearing regarding money damages, that'll be at a different time and place. All I'm telling you is if you pay this amount, $224 for 5 months plus court costs, you get to stay there. Rent will be calculated at a different amount for May. All right. I appreciate everybody's effort in this. Meg, do you want to talk for? Well, I'm going to shut everything down.
Yeah,
So
I'll call her.
if you need to call your lawyer, you can call her.
We'll discuss what is in your strategically the best interest in light of this the judge's decision.
All right. Thank you all.
Thank you, Your Honor. Take care. Thank you, Ken. Take care, Meg.
Thank you.
Thank you, Ms. Cleveland.
Thank you.
Man, oh man, you know, I hate that it's, you know, Friday, and we didn't end Friday on fun. But tomorrow, ladies and gentlemen, in just a few short hours, 11 a.m. Central Time, we'll have the weekend review, and I've got some fun cases lined up. But that Enchanted Glen case is something we've been following for so long, and it ran on so long. I decided we had to do all Middleton tonight because some of the Middleton stuff was pretty fun, kind of interesting. That Enchanted Glen case had me seething for most of the time I saw it on. So I hope you thought it was as interesting as I found it. I know we all hope the best for all the players involved, with the exception of maybe some of the people that work at Enchanted Glen, but we still hope their life is fine and dandy and all that type of good stuff. We just wish they'd do their paperwork right sometimes. I think it's the general consensus, right, people? I'm not speaking out of turn here. Help me, chat. Ladies and gentlemen, I am your Lobo Fusel. I bring these stories to you from around the country and all of the court tubing community, hoping that we can all find a few moments of shared humanity and a little bit of enlightenment along the way about things going on around us in the court system and all that type of good stuff. And we do it every single day here, every single day of the week. We do not rest, no, ladies and gentlemen. But those puppies, they rest. They got it good. Ladies and gentlemen, 11 a.m. Central Time, 12 p.m. Eastern Time, I will be back with another few hours. And we're going to be watching some mermaids battle it out. I know some of you may have already seen that, but hey, we got to watch it and we got to talk about it. Ladies and gentlemen, I'm your Lobo Fusel. I am your host for these here little get-togethers, and I'm the curator here at the Court Gallery. And for now, I am out. Thank you all. Thank you, Kieran. Pennebrich. P-N-E-B-R-I-C-H. How do I pronounce that? Anybody? Julie Sass, thank you for being here. Hannah Falk, thank you for being here. Becky, great to see you. Kami, welcome. Muse, hey, man, I hadn't seen you in a while. Bermiticus, Mom, thank you for being there. Rhonda, Math Girl, I'm sorry you had to check out so early, but adding up the time and everything, and we really appreciate it and all that type of good stuff. Anna, Crazier Cat, I am low. Kiernoth, Becky, Pat. Oh, you crazy people. You're awesome. You know that? Thank you so much. In tonight's episode of the Court Gallery, a special shout out to our hero of the evening, Meg. Thank you, Meg, for all you do. We just simply appreciate it. And that's just all there is to it. Period. Done.